Hi guys, very warm welcome from Lokesh Pathak and welcome to the class number 9, which is Offences Against Human Body, and this is basically based on the chapter 16 of Indian Penal Code. So here we will see what are the offences against human body, and we'll touch all the possible or the famous offences which are covered in this. We'll start with culpable homicide, then we'll cover murder. After that, we are going to cover hurt and grievous hurt. Then we will cover the wrongful restraint and wrongful confinement and the differences between them. We will touch assault, and finally we will see what is kidnapping and abduction, followed by rape. So this all we are going to cover in today's class. So this is going to be a bit longer duration. So have patience and listen carefully. So to start with, I would like to start with culpable homicide, which is section 299 of IPC. So first of all, before we go into details or what the IPC says, let's see what culpable homicide is. Culpable means blameworthy, while the homicide means killing. So any killing which is worthy of a blame to somebody is called a culpable homicide. Or in literary terms, you can say it is causing death by doing an act which has three conditions, and that condition is: number one, an act with the intention of causing death; number two, with the intention of causing such bodily injury as to likely to cause death; or third, with the knowledge that he is likely by such act to cause death. So it means if a person causes a death by either the intention of causing death or with the intention of causing any body injury which can later be converted to death, or with the knowledge that what he is doing or causing it will result to the death, then he is supposed to be under the culpable homicide. Now there are certain explanations in IPC for that. There are three explanations which I'll take up. The first one is causing bodily injury to a person laboring under a disorder, disability or bodily infirmity, and hence accelerating the death. What will be the consequence? It will be equally responsible as if he has caused the death. Means if you without, irrespective of your knowledge, if somebody is under any disorder, disease or any bodily infirmity, and you hit him or you try to make injury to him, and this accelerates his death, you will be held liable for the causing the death. Explanation 2. If death is caused by body injury of a person who is getting injured, so the person who made the injury is responsible, although the death might have been prevented by proper remedy and skillful treatment. So it doesn't mean that the offense or that the injury which was caused, that could have been skillfully treated. That is not important. Important is that whether it was available or not, whether it was given to the person or not, but if the person is dead, then you will be held liable for that. Explanation 3 is with relation to the abortion of the kids. Explanation 3 is causing death of child in mother's womb. It's not homicide. But if the child is living and any part of child has been brought forth, it becomes homicide. This is immaterial that the child has not breathed or completely born, no. But if you brought forth any of the part of the child and he's living, it will become homicide. Now there is another case. Sometimes it happens that the death is caused to a person other than the intended. Means the person tried to made some conspiracy to kill a person, but instead of that, other person is killed. Then in that case, the person who's conspiring, he'll be charged for murder. This was seen in the case of public prosecutor versus Mushandru Sundarnarayana Murthy, which is 1942 case. Now what is the distinction between culpable homicide and murder? Now it is said that culpable homicide is a complete genus, while the murder is the species. This is a famous words or interpretation, and there was a case which is Rampal Singh versus the state of Uttar Pradesh. It is a 2012 case, and that it was said that all murders are culpable homicides, but all culpable homicides are not murder. Means murder is just a subset of the category of culpable homicides. So murder is defined in section 300. So these are all the standard definitions person can see. There's not much to discuss about it. You can go through section 300 and you can read the conditions of the murder, which is almost similar to what we discussed in culpable homicide. But what important to know here is what are the essentials of the murder. There are two prime essentials of a murder. The first is the intention to kill, and the second is the evidence to how the death came. If any of them is not available, we cannot say that the person has committed the murder. Now, for the intention to kill, the reference I would like to give is a case which is Prabhu versus the state of Madhya Pradesh. It is 1991 Supreme Court case. In that, it was held that the number of injuries inflicted the intention of the person, and hence it was held that the person intended to kill the person. So the importance of intention is elaborated in the case. Now the second case I would like to refer is Kedarnath versus the state of Madhya Pradesh, which is Supreme Court 1991 case. In that case, it was held that there was a insufficient evidence. So the importance of evidence was held in that case, and it was important to substantiate that the reason of coming of death was the point which is being claimed. While we talk about the evidence, it is important to know here that evidence has to be in a proper form to hold the offense. So, like we say that there is a postmortem report. Just for your knowledge, that the postmortem report alone cannot be made sole basis of a conviction. A postmortem report added with a eyewitness becomes a proper evidence. So we should know what are the acceptable evidences, and there is an act for that, which is Evidences Act. So that can be discussed later sometime. Now, let's discuss about the punishment of murder, which is mentioned in section 302. The punishment of murder is death or imprisonment of life, and also shall be liable to fine. Section 303, it says that whosoever under sentence or imprisonment of life commits murder shall be punished with death. So section 303 is very clear that if a person who is already under a life imprisonment, and if he commits murder, in that case there is only one resort for him, that is death. Now section 304 speaks about the punishment of culpable homicide but not amounting to murder. So if the person is charged of culpable homicide only and there is no murder possibilities there, then there are two classifications of such punishment as mentioned in section 304. The first is intention of causing death, and the second is knowledge that it is going to cause death but there was no intention. So in the first case, when there is the intention, the punishment is life imprisonment of 10 years and fine. While in the second case, it is relaxed to some extent, because where there is a knowledge that the possibility of death will be coming as a consequence, but there was no intention of the person, then the penalty is 10 years imprisonment or fine, or both. Now, section 307 talks about the attempt to murder, and the punishment mentioned in section 307 is 10 years imprisonment and fine. However, it has two further categories, that if hurt is caused in such attempt, then it becomes life imprisonment of 10 years and fine. And if attempt is done by a life imprisonment convict, then again the consequence is death only for him. So this is all about culpable homicide and murder. Now the next topic here is hurt and grievous hurt. So first of all, we should know what sections determine this, the provisions of these two. Section 319 to 325 talks about hurt and grievous hurt, although the punishment and all, they are mentioned in further sections, and it can go up to section 333. So typically we'll see that section 319, it defines hurt. So hurt is what? Causing bodily pain, disease or infirmity is hurt. I am making it repeated. It's very clear as per the law that if you cause bodily pain, disease or infirmity to somebody, then you are supposed to create a hurt or cause a hurt to him as per section 319 of IPC. While section 320 gives a comprehensive definition of grievous hurt. It determines grievous hurt in 8 categories. If any of those 8 categories is satisfied, the person will be deemed to have caused the grievous hurt to the other person. These are, the first is emasculation, the second is permanent privation of sight of either of the eye. Similarly, third is permanent privation of hearing of either of the ears. Fourth is privation of any member or joint of the body. Fifth is the destruction or permanent impairing of powers of any of the member joint. Sixth is permanent disfiguration of head or face. 7th is fracture or dislocation of a bone or a tooth. 8th is any hurt which endangers life and which causes bodily pain or inability to follow ordinary pursuits for 20 days in the life of a person will be considered as a grievous hurt. So these all 8 categories is, if any of them is satisfied, then it will be considered as a grievous hurt. Now, I would like to refer a case here, which is a State of Karnataka versus Shivalingaya, which is Supreme Court case of 1988. In that it was held that the act of squeezing the testicles of a person is also coming under the category of grievous hurt, not the hurt. So, section 321 and 322 talks about the voluntary causing hurt and voluntary causing grievous hurt. So, both of them tells the same thing, that if there is an intention or knowledge of the hurt, then it becomes a voluntary hurt and it is covered in section 321. Similarly, when there is an intention and knowledge for a voluntary causing grievous hurt is there, it is covered in section 322. The punishment of voluntary hurt is mentioned in section 323, which is 1 year imprisonment or fine of 1,000 rupees or both. Similarly, section 325 speaks about the punishment of voluntarily grievous hurt, which is 7 years imprisonment and fine. So this is all about grievous hurt and voluntary grievous hurt. Other conditions or other punishment extending it to grievous hurt to a police person or the service person and all, that can be seen in other sections, but that are not so important. So the next category of offences against body is wrongful restraint and wrongful confinement, which is mentioned from section 339 onwards up to section 348 of IPC. Section 339 says, what is a wrongful restraint? It defines the wrongful restraint as voluntarily obstructing a person so as to prevent from proceeding in any direction in which that person has a right to proceed. So if a person has the right to proceed in a particular direction and you stop him, you obstruct him with your knowledge, voluntarily if you obstruct him, preventing him to proceeding in that direction, it is said that you are doing a wrongful restraint. The case here is Mahindra Nath Chaudhary versus Emperor, which is ILR case 62, where the person's liberty obstructed. However, there were certain exceptions that the obstruction of a private way over land or water is not included. Now, similarly, section 340 says wrongful confinement, which defines it as preventing a person from proceeding beyond certain circumscribing limits. So, if there are certain circumscribing limits and you prevent a person from proceeding beyond those limits, then you will be held liable for creating a wrongful confinement to that person. Here there is a case which is State of Gujarat versus Maganbhai Jogani, AIR 2009. In that, a court held surprisingly that there was no wrongful confinement, and the fact was the officials gone to a person's house, they were not allowed to go from the accused house, but there was no use of force. So court held that this situation does not call for a wrongful confinement. The punishment for wrongful restraint is mentioned in section 341, and it is simple imprisonment of 1 month only and fine of rupees 500 or both. While the punishment for wrongful confinement is mentioned in section 342, which is an imprisonment of 1 year or a fine of 1,000 rupees or both. But this is a general punishment. If the wrongful confinement is made for more than 3 days, then section 343 is applicable, which says that the punishment is 2 years imprisonment and fine on both. While 344 says that if the wrongful confinement exceeds beyond 10 or more days, then the punishment increases to 3 years imprisonment and fine. Now the next category of the offense is assault. Assault is included in section 351 to 358. So what is assault? This is an important point because it is a bit tricky. The conditions of assault are a bit tricky. Assault is making any gesture or preparation. Be mindful what I'm saying. Making any gesture or preparation, intending or knowing that it will cause a person to apprehend that the one who is making it is about to use criminal force. Before we go in the details, let's discuss what the criminal force is. Criminal force is defined in section 350. And that is, criminal force is, there are 3 conditions. First is intentionally using force to any person without his consent. Second is to commit any offense. And third is intending or knowing that such force will cause injury or fear to that person. So this all is summarized again here in the form of assault. Assault says not the application of criminal force, but making a gesture or preparation which will make the person against whom you are making to apprehend that you are going to use the criminal force. And this, if you are doing with the intention or knowledge that the person will feel this way, then you are said to have committed assault. There is an explanation to it that merely words are not assault, but words giving the gesture or preparation of criminal force is considered as a assault. So your gesture and preparation is important, not only the words. Punishment for assault is 3 months imprisonment or fine of 500 rupees or both. Now there is a case which is Jadunandan Singh versus Emperor, which is AIR 1941, before the freedom of India. And it was held in that case that forcibly taking thumb impression on a blank paper from a person is also a form of assault. So this is all about assault. There are other extension of the punishment in terms of public servant and all that are not so important while we discuss the basic things. The next and the last topic in the offenses against body is kidnapping and abduction. Kidnapping and abduction, it is defined from section 359 to 365. Kidnapping is in section 359 says that kidnapping is of two types. One is kidnapping from India and another is kidnapping from lawful guardianship. Kidnapping from India is defined in section 360 again, and it defines it as conveying a person beyond the limits of India without his consent or the consent of a person who is legally authorized to provide his consent is called the kidnapping from India. While the kidnapping from lawful guardianship, the second one, it is again defined in section 361, which says that kidnapping from lawful guardianship is taking or enticing any minor under 16 years of age for male and 18 years of age for female, or any person of unsound mind, out of keeping of lawful guardian without the consent of such guardian. So while you have seen, while the 360 and 361, while the 360 which talks about kidnapping from India, it's kidnapping it's taking the person beyond the limits of India without his consent or the consent of the legally guardian. While section 361, it talks about the kidnapping from lawful guardianship, and it is applicable for a male under 16 years of age, for a female under 18 years of age, or any person of unsound mind, if he's taken away or enticed away out of the keeping of lawful guardianship, then it is called as kidnapping from lawful guardian. Now, what is lawful guardian as per law? The person who is lawfully entrusted with the care and custody of a person is called a lawful guardian. While section 362 talks about the abduction. Abduction is compelling by force or inducing by deceitful means any person to go from a place. So it means if you force a person by use of, if you make a person to leave a place by use of force or by inducing any deceitful means, then it is called abduction. So in the case of Abhay Jina versus the state of Orissa, which is 1997 case of Orissa jurisdiction, it was held that abduction and kidnapping are distinct offences. They are not one, they are distinct. While section 363 of IPC, it provides the punishment for kidnapping. It says that it is 7 years imprisonment and fine. While section 364 extends the kidnapping or abduction to murder. In that case, the punishment is life imprisonment or rigorous imprisonment of 10 years and fine. While 364A says that the kidnapping for ransom, it is punishable by death or imprisonment for life and fine. So this is all about kidnapping and abduction. Now we'll go to the last topic, which is rape. Rape is defined from section 375 onwards in IPC. 375 defines rape as a man is said to commit rape if he, there are 4 conditions, penetrates his penis to an extent into the vagina, mouth, urethra or anus of a woman, or makes her to do so with him or any other person, or B, inserts to an extent an object or a part of a body, not being the penis, into the vagina, the urethra or anus of a woman, or makes her to do so with him or any other person, or C, manipulates any part of the body of a woman so as to cause penetration into the vagina, urethra, anus or any part of the body of the such woman, or makes her to do so with him or any other person, or the last one is applies his mouth to the vagina, anus, urethra of a woman, or makes her to do so with any other person. Now, there are further conditions, but this is the typical classification of rape. And the punishment for rape is defined in section 376, which is rigorous imprisonment of either description for a term which shall not less than 10 years, but which may extend to imprisonment for life. Similarly, there are certain sub-classifications of rape which are defined there. In section 376A talks about the punishment for causing death or resulting in a persistent vegetative state of victim. 376AB talks about the punishment for rape on women under 12 years of age. And then there are other sub-classification, but the important definition is gang rape, which is 376D. And here it is defined as the situation where a woman is raped by one or more persons constituting a group or acting in furtherance of a common intention. Each of those persons shall be deemed to have committed the offence of rape and shall be punished with rigorous imprisonment for a term which shall not be less than 20 years. So minimum punishment here is 20 years, and which may extend to the life imprisonment. The last topic in rape is section 377, which is unnatural offence, which says whoever voluntarily has carnal intercourse against the order of nature with any men, women, or animal shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. So this is all about the offences against human body. You may feel that the topics are not totally covered, because once we speak about something with relation to the first semester of first year, we should be very objective in covering the topics, their basics, and the punishments. If you try going into all the details of IPC, all the 550 plus the sections, it's not possible to present all them in a lecture. So the purpose here was to make you aware, first, with the classifications of these offences, second, their definitions, their meanings, their references from IPC, how they are different, and certain extrapolations to their punishments and applications, which is very much necessary to be known from a graduate in law. So I hope I would have made justice to this, and in the same pattern, in the next class, we'll take about the offences against property. Thank you.